process for bringing an
Mhm.
urgent or emergency motion
Mhm.
is, again, all the forms that you need are, you can get off the Ontario Court Forms Court Forms site. Sorry,
Mhm.
I tried saying that 3 times quickly. So what you need to do is complete your urgent motion materials, which is the Form 14 notice of motion and the affidavit. You'll leave the date part blank because that'll something you'll have to get from the court staff because they'll be able to tell you when the motion is going to be heard. As I said, it'll usually be within a week if you are if you are having to serve the other party, because you're going to have time to file responding material. Or if it's on our next party basis, it could even happen the same day. But what you always do is you'd leave the date for your notice of motion blank and let the court staff determine what you should be putting in it. When you do your Form 14A affidavit, that is like any other affidavit, it's a sworn statement. So that means that you are going to have it sworn or affirmed before a commissioner for taking oaths. And again, that's why we usually recommend as duty counsel or the advice lawyer, if the people feel they have to bring an emergency motion, to bring the documents to the court counter, because the counter staff can swear your affidavit. And they don't charge for doing it. You can get your affidavit sworn by any commissioner for taking oaths. All lawyers can do that, but most lawyers would charge you for that service if you see them. Okay, with respect to claims that you can make, there are a number of different things you can ask for. You can ask for an order putting restrictions on the other parent's parenting time. You can ask for an order that the other parent have no contact or communication with you or the children at all. But again, this would be for a very short temporary period until you can get things settled down. It might be that neither one of you is allowed to remove the children from the municipality in which they're currently residing. You could be asking for an order that passports get held by the court or by one party until such time as the court agrees they can be released. Quite often the situation where you'll see an urgent or emergency motion being brought is when there's an existing status quo in place for kids moving back and forth between parents, and the one parent withholds the children or says, I'm moving with the kids to Nova Scotia and you can't stop me. So in those kind of situations, there's a number of additional clauses you'd be asking for that are standard form in these kind of orders. It can be for a request for police enforcement. And there's very specific wording that the courts would look at and would put into an order that says that the police of whatever jurisdiction or location are directed to enforce the return of the children to the other parent, that they can locate and apprehend the child at any time of the day, like 24 hours a day, that they can call on or bind other police forces like the RCMP or OPP, not just the municipal police force if it's appropriate, if it turns out that the child may no longer even be in the municipality where you think the children lives. Yeah.
Okay, quick question here. This is great because actually one of the questions I wanted to ask about the police. Let's say that you're successful in getting this order. Does the court send this order to the police station? Like, or do you have to, okay, what happens then? Like, what happens after you get the order?
Once the judge makes the order,
Yeah.
that's why usually what you try to do is, if at all possible, you even have a draft order done.
Okay.
Again, that's why it's really a good idea to try getting some legal advice and assistance when you're doing it to make sure you've got the right clauses in there.
Yeah.
But what'll happen is it's like any other order. The judge will make an endorsement.
Yeah.
The party has to get the order taken out and issued in as a formal order.
Right.
And then it is the party contacts the local police force or the RCMP or OPP and gives them a copy of the order. So the police can then take the order and go out and enforce it. The court does not contact the police forces directly. It's still up to the party to get the order taken out on a formal basis.
Okay.
And then bring it to the police.
Wow.
I have very rarely seen situations where a judge has made an endorsement and it's the judge's handwritten notes about saying, I have heard this emergency motion. I agree there's a need for police enforcement. I hereby direct the police force of blah, 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 to locate, apprehend, and deliver the child to the person that brought the motion. And I have seen, but again, as I said, not very often, a situation where a party has just taken the judge's handwritten or typed out endorsement. So it's not even in the form of a formal court order yet.
Yeah.
and brought it to a police station.
Oh, wow.
And again, depending on the police force, some will just act on the endorsement. There are
I
others where they're
see.
saying, no, you have to have a formal court order with the seal on it and everything else. So it's always something I always recommend, if at all possible, is to file a draft order with your note, or bring a draft order with you when you
Yeah.
argue your motion.
Yeah.
And then you can even just strike out the clauses that don't apply and just
Yeah.
keep in the ones that do work. So you're not going to have to take the time to do the order then once you've got the order granted.
So
Okay?
the draft order, the judge will sign right away after the hearing, you're saying?
Now, what'll happen, yes, if the judge makes the endorsement,
Yeah,
then if you can do the draft order and get it to the judge, then yes, the judge will sign it.
at the same time. Wow, that's good. That's really good tip.
Yep, no, it's a good thing to know.
Okay.
Now and
Yeah.
again, different jurisdictions handle things differently. As I said, I do a lot of advice lawyer and duty counsel work. You and I have talked
Right.
about that a lot. So I'm
Right.
helping a lot of people that are going to court that don't have a lawyer of their own.
Right.
Quite often, these people that are having to do an emergency motion, they haven't been able to get a lawyer because they're
Yes.
having to do it in such a hurry. They're trying to figure it out
Yes.
on their own and they can't do it.
Exactly.
If they meet legal aid's financial eligibility requirements and the motion, like they can go to an advice lawyer or a duty counsel in the jurisdiction where it'll be going to court.
Yeah.
And in some jurisdictions, the duty counsel will assist by helping people do their documents, but that's really, really rare.
Oh.
The other option that is available, and I know I do this, and I've known a couple of other duty counsel to do it as well. I actually
Mhm.
have a crib sheet. The discussion sheet we're actually looking and discussing now is based on an information sheet that I keep available. So if I'm speaking to somebody as the advice lawyer, I can give them the instructions and information on how to do an emergency motion. I can give them an example of what a notice of motion and the affidavit may look like. And I
Ah,
can also give them, and I quite often do give them the sheet with all of the potential orders that you can or should be considering when you're looking at bringing an emergency motion,
but
so that they can make sure they're getting the right wording and the right things that they should be asking for in their notice of motion.
right, but this is for people who qualify for legal aid for the service or
Yep, and again, it depends on the
oh,
jurisdiction which you're in. Some jurisdictions
mm,
have duty counsels that will do very similar work
mm,
to the way that I do it. There are others where they will just say,
I
no,
see.
sorry, you're gonna have to go to some of the online resources such as the Steps to Justice website, which
Right.
also has instructions and information on how
Yeah.
to do an emergency motion.
Yeah.
I like the forms that I've got that I use because I think they're most helpful, but they're
Mm,
not mandatory for duty counsel or advice lawyers to use. I just do them because I
mm,
get frustrated when I know I can't sit and actually draft the materials for the people,
mm.
but they should be getting it to court, and you don't want to see them waste their time by spending hours doing the stuff and then have it turn out that their motion gets rejected just because they didn't do the paperwork right.
Yeah.
You always first of all have to make that decision whether you're going to try bringing your motion on a without notice basis, or if it's still an urgent situation, but not one that is really, really, really urgent, so that you can take the time to get the other party served and give them a chance to file their responding materials as well. You need to figure out if this is a situation where one party is withholding the children from the other side, whether it's one that you should be asking for police assistance and enforcing the return of the children to the other parent. Again, one of the things that I quite often will hear, and it's hard for people to hear because they get very freaked out, is in a situation where you might have had a parenting arrangement in place for years, and something happens on one particular weekend, and the kids are with one parent on that weekend, and that weekend at the end of the visit, the parent decides, no, that's it. Something's happened.
Mm-hmm.
I'm mad. I think the kids are at risk. I am not going to return the children, or I'm not going to give the children to the other parent, or
Mm-hmm.
withholding the children when they're supposed to go with the other parent for a weekend.
Mm-hmm.
That's not an emergency. That's,
Mm-hmm.
it can be something where there's an issue of, if it only happens once, then the parties are really strongly encouraged to try working through it. But if it turns into an ongoing refusal to allow the other parent parenting time, then it becomes something that you might consider wanting to bring an emergency motion for. But just because somebody on one weekend just says, okay, I want to keep the kids overnight because our agreement or the order says that I've only got them till Sunday night, but tomorrow's a PD day and I got the day off work, I want to keep the kids. I'm not bringing them back, then the other parent really is probably not going to get very far with trying to bring an emergency motion to have the children returned, because the person's not saying they're taking the children away. They're not saying, I'm never going to return the children. It's just been basically contempt of an existing court order. And if a pattern gets established, then the thing to do is to have it brought back to court on either a contempt motion or to enforce the terms of the existing order. Like I said, so you really have to play your cards smart and make sure that you really have an urgent emergency situation before you try bringing one of these motions.